5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth. Now I'm talking and you just cutting me off. Do you understand how this process works?
Oh, yes. Come on, this is not slavery. I'm not the one, I am not the one. I don't even have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to. I don't have to answer you, and I don't answer to you. And I'm not going to start now.
Today we're in court with a defendant facing felony retail fraud, but instead of focusing on the charges, he's arguing that the court has no authority over him. Rather than answering simple questions, he keeps debating the judge and can't even decide whether he wants an attorney or to represent himself. The judge stays patient, but it's obvious this hearing is heading in the wrong direction. Let's dive in.
25S00791. FY, people say the Michigan versus Timothy Dance.
Declaring on behalf of people.
Illinois, except 146, Stephen in for the attorney of record, John Donovan, appearing on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state the name for the record?
My name is Timothy Dansby, and I'm often represent myself and I'll take counsel as an assistant, you know. But I don't know who this being there. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer? You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery pack.
Well, that's what we got lawyers for, sir.
To the count machine to get to the lawyer very well to the county. So it's paying me hard. So I'm going to need some type of system.
Okay, well, that's what we got for you. Okay.
I'm going to represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
So first, I want to go ahead on with the preliminary.
Okay, well, first of all, you're charged with retail fraud first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge,
I believe it's 5 years.
yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain to go with you.
Well, you can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. If nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying.
This defendant wants to represent himself, yet keeps asking for legal help at the same time. That's exactly why self-representation is so risky. Instead of listening, he argues about legal procedures that don't even apply at this stage of the case. Confidence without understanding the law is a dangerous combination, and the judge can see it immediately.
This charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So, preliminary examination is the probable cause hearing where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. So, you understand all that? Now, you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Dansby today, and have not received any audiovisual discovery from my understanding.
I'd like to be honest, if you don't mind. Part of motion, you know what I'm saying, for the fact that I haven't been denied, you know what I'm saying, in the time denied, you know what I'm saying, in the prosecutorial misconduct of the government change, even though
okay, that's a lot of talking. Where's the prosecutor? Where's the prosecutorial misconduct?
Well, I should have had my discovery, guys.
Sir.
Yeah.
Do you understand how this process works?
No.
Well, no, you shouldn't have had your discovery because this is the first hearing.
So it's not the first hearing. I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just say, oh, yes, come on, this is not slavery. I'm not the one, I am not the one. I don't care nothing about the United States. First of all,
apparently not. You must not care too much about anything, sir. Okay.
I don't even have a license plate. What's your license plate?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days? No, you don't care. That's why you're here charged with something.
What is your license plate?
I don't have to answer you, and I don't answer to you, and I'm not gonna start now. You need to settle down. You need to settle down. Okay, take him out of here, please. That's a He's just having his moments.
Bringing unrelated arguments into a felony case isn't a legal defense, it's a distraction. The judge keeps trying to move the hearing forward, but the defendant insists on turning it into a debate. Every unnecessary argument only hurts his own position and makes the—
So we're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right. So we'll give you what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's gonna want to see it, so you're probably gonna need to have him take the laptop over there to the jail and take his license to practice law to him. Okay. All right. So the next probable cause conference on this charge is gonna be.
I just to make the record as regards to that discovery. I do have paper discovery, which counsel has noted that has been tendered already. I do not have. Does not agree that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. If it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30, and hopefully your client will have had a chance to review everything, and we'll be a little more settled down.
Mr. Dominic will be in trial in the Wayne County Third Court. I make that paperwork for myself, but if you're wanting Mr. Dominic to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance, I would be more comfortable if Mr. Gonick just handled his own.
Well, you know what? You got to cut your teeth somehow. We've all had this.
Just don't.
Ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got Miss Gracie right. He's an expert in us.
I've had my share over the years when I was licensed to practice law. So by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.
The judge gave him multiple chances to calm down, cooperate, and focus on the case, but he chose to keep arguing instead. There's a big difference between knowing your rights and misunderstanding them completely. When years in prison are on the line, this isn't the time to experiment with courtroom theories. What would you have done in his position? Let me know in the comments.